Hi everyone, welcome to Legal Talks by Desi Kanoon. I am Suyash and I am excited to have started this show. On today's show, we will discuss a case that has a checkered history. The name of the case is Reserve Bank of India versus Jayantilal N Mistry and Another. This case involved questions relating to disclosure of financial information under the Right to Information Act. In order to understand the matter, let us go through the chronology of events that has transpired in relation to this case. On 16th of December 2015, the Supreme Court in the case of Reserve Bank of India versus Jayantilal N Mistry had held that the public has a right to know about the functioning of the RBI and the banks. This includes details such as inspection reports, risk assessment reports, and annual financial inspection reports of the banks. This also includes any lapses in regulatory compliances, and merely because such disclosure may adversely affect the public confidence cannot be a reason for denial of information under the Right to Information Act. The court further elaborated in this case on Section 8, subsection 2 of the RTI Act that provides that if public interests in disclosure outweighs the harm to the protected interests, then such information ought to be disclosed. It was also observed in this case that transparency counterbalances arbitrariness, mistakes, and corruption. There must be transparency as regards such organizations so that citizens can make an informed choice about them. Then, in another judgment in the case of Girish Mittal versus Parvati V. Sundaram and another, in the year 2019, contempt petitions were preferred in relation to non-compliance of judgment dated 16th of December 2015 that we just discussed. Now, in this case, the Supreme Court disposed of the contempt petitions by granting the Reserve Bank of India and other banks one last opportunity to comply with the judgment dated 16th of December 2015 and make appropriate disclosures relating to inspection reports and other such materials. Thereafter, certain impleadment applications were filed in the case of RBI versus Jayantilal N Mistry that we are discussing today to seek recall of the judgment dated 16th of December 2015 on the grounds that A. Some banks were not made party to the case and application for recall is maintainable where there is a violation of principles of natural justice. B. Recall is different from review. And C. The court did not consider the aspect of violation of right to privacy due to disclosure of such financial information, and many other important questions of law were not considered. Now let us understand what was held by the Supreme Court in this case. Firstly, the court observed that there is no provision for seeking a recall of the judgment in the Supreme Court Rules 2013. And applications filed for clarification, modification, or recall are often only a camouflage for review petitions. It was further observed that filing applications which are not maintainable amounts to abuse of process of court. So, according to the court, there is no provision for seeking a recall of any order or judgment in the Supreme Court rules under which all the applications and all the cases are filed before the Supreme Court. Secondly, the court explained the difference between review and recall and stated that recall petitions are entertained when a person directly affected by a judgment is not heard. According to the court, in the present case, the matter pertained to information that was provided by the RBI under a law, that is, under the RTI Act. The RBI challenged such disclosure and it was within the knowledge of the banks that this case was filed. The banks did not make any efforts to get themselves impleaded at that point of time, and the applications styled as recall applications in the present case are essentially seeking review of the judgment dated 16th of December 2015. Thirdly, based on the reasoning that we just discussed, the court held that recall applications filed by the Reserve Bank and the banks are not maintainable as nomenclature of an application is of no consequence. Thus, the applications filed by the RBI and the banks were dismissed. Those were the observations of the court. So, what are my concluding remarks? I feel that Reserve Bank of India and other banks are public institutions that run on public money. It should be asked from them the amount of money they wasted in challenging the judgment dated 16th of December 2015. And why are the RBI and the banks so afraid to disclose basic information about their financial health to the general public? Filing review petitions in the garb of recall applications is something quite deplorable. Recall applications are generally filed when an order passed becomes difficult to be implemented due to reasons such as abrupt change in circumstances, absolute non compliance of principles of natural justice, or where an order has been passed without jurisdiction. Whereas, in the case of review petitions, they are preferred where there is an error apparent on the face of the record, such as blatantly wrong appreciation of law or ignoring an established legal precedent, etc. I think the court rightly held that in the name of recall, review is being sought. I hope that this is the last round of litigation in relation to the issue of disclosure of public information by the RBI and the banks. It is the public money that is lying with the RBI and the banks. The banks and the RBI must not forget that they must disclose the relevant financial details. Hence, I hope you enjoyed listening to this show. Thank you for listening. Please do not forget to like and subscribe us. And if you have any comments, please make them in the comments section. See you next time. Till then, stay tuned.